on the last day, when your lordships had asked the respondent that the list of those people who were the 20 to 22 batch, that should be produced, the merit list. As per your lordships,
we are 40. After another SP, please. Everybody don't talk to them.
Yes. So there are a number of applicants. I will give the particulars about all of them. And let me just introduce what my case is. And then I'll tell your lordships, my lord, how actually the whole issue can be concluded, because there are more than 2,000 vacancies. And the number of people...
And the only question which will arise, even if we assume, if we can conclude that the interpretation of the rule by the High Court is not correct, then the question of, as Mr. Gupta was saying last time, that the select list has expired. Perhaps that's it.
It's not. There are 9,000 people appointed. My learned friend was appearing, and in spite of the fact they are appointed, he was opposing relief to us. So, my lord, I am going to show the rule to your lordships today and say that even their appointment therefore cannot sustain.
Hold the rule in your favor.
Yes, it is.
So how can relief follow? Because in the meanwhile,
we have already been declared eligible.
2022.
We have already been declared eligible. We have already participated. Only our result is not being. Let me just give your lordships a few facts. We are people, my lord, who did this diploma, 2-year course.
Asking you that, you get the point.
Yes. We have participated.
Select list part of it, there's a problem.
Yes. Now even the rule. Now I tell your lord. Last time my Lord Justice Mishra had said that is there a power to relax under? That's your lordship had asked. Now the rules are on the record. I'm going to show it just now. But please see the rule with me. At page 5, the rule is there. Kindly see rule 6.1 and 6.2. High Court is not right in interpreting the rule.
We agree with you. Prima facie, we agree.
Yes, the rule doesn't want
the rule is not intended to say that you should have got the qualification by that time.
Correct.
It is intended to say that this is the qualification which should be
obtained. Correct. The NC.
When it should be, in fact, in every recruitment process.
Correct. Now see the advantage.
By the time the interview takes place, by which time you will, because JEE and all other examinations pass through the graduation.
We had got it.
You get now, certificates. And
now, what is our case? We got selected in 2020 in the diploma course, 2-year course. We would have qualified by June 2022. Because the board was not in position, our training was certified to be complete in June 2022.
What she also said last time. We can't be interpreted.
I know.
We wait for qualification. You are on this side, this side.
No, I'm going to tread on his toes in a bit.
Yes.
But so, a group of people,
wait.
Because have been referred to court number 2, we need to be protected. Same advertisement.
No.
What court number?
Who are the
This has been going on for a while. They've been trying to step on everybody's toes.
The same.
Yes. Lord, I have a suggestion to make in this one.
Tell us, because
I have a
suggestion. We will, of course.
Your lordship may hear me. I will cover everything. And
Prima facie on rule interpretation, perhaps we are with you. We have heard them. Hear them.
So,
second question arises as to you, pursuant to the amendment in the notification, you appeared and you perhaps were.
No amendment.
What happened after that?
I just.
What happened after that?
Yes, only 2 minutes. We are students who got admitted in June 2020. We should have completed the diploma in June 2022. That completion of diploma means 2 years training and examination of the first year and the second year. 2 years training completion certificate is given to us on at page 147 in June 2022 itself. Since our examinations are not being held, in August 2020 we filed a writ in the High Court in 22 for a mandamus saying, please hold the examination. That when the writ is pending, the first year examination is held in September. On 29th September, the result of that examination is declared. The writ comes up for hearing on 29th September. On 29 September, the High Court passes an order
Single judge passed the order.
at 217 saying that they should be also considered in this process. On 29 September itself, the board publishes the first notification. First notification specifically includes us as participating. Thus, the second notification is published on 21st October. The second notification also includes, these two notifications are there at page 219 and 222. The second notification also, yes, 219 and 221. Second notification also includes us.
Yes.
These notifications, the order of the single judge is then taken up in appeal.
Division bench says that's virtually a cutoff, so you can't have it.
Yes, the division bench says you should have got it on the date of the advertisement. Now, the board does not, the board files an affidavit completely in our favor, which affidavit is reproduced by the division bench at page 12 onwards. And the board accepts at page 13. I want to read two paragraphs at page 13, para D and E. Please read those two paragraphs. The board says we are at fault. Yes. Now, subsequently, what happens when this judgment is reversed by the division bench? We come here. By that time, we have already participated in the selection process. Interviews are also over. Our second year result came on 30th December. So on 30th December, all results were out. Interviews are conducted after 30th December.
December 22, right?
Correct. So interviews are subsequent to 30th December. So yes. So when we came and filed this SLP, your lordships in the first instance passed an order. No merit is to be declared till this SLP is decided. That order is the first order of 28 July 2023.
Is it this bench's order? No,
no, bro. It is an earlier bench. 28 July 2023. 28 July. Until further orders. Para 8 of this order, after on the day when notice is issued, until further orders, the West Bengal board. Lords have the order? 28th July, the very first order in this SLP. That will be the very initial order.
28th July, correct. Right.
It says, until further orders, the respondent West Bengal Board of Primary Education, last para I am reading, is restrained from declaring the merit list.
Oh.
Then what happens? The board comes. The board says, sir, now just see the 29th January.
Is that varied subsequently?
Yes. On 29 January, that order is varied because the board says we have 11,000 vacancies. The number of candidates just see.
Completion show 22nd and 23rd.
All right, your lordship may then first have 22nd January order. 22nd January.
They filed an affidavit in
Correct.
The first interim order, as you were saying, is
28th July. This is modified, or there is another order. This will be modified later on 22nd January.
24.
Yes. Correct. In the first instance.
Yes, we got it.
My Lord Justice Michigan.
Yes. That was heard a number of times by the bench of Justice Imakoli.
Yes, my Lord, yes. In the first instance, the respondent West Bengal Board of Primary Education is directed to file an affidavit furnishing inter alia the details of the number of vacancies that were advertised for the subject post, the number of candidates who had applied in response to the advertisement, and the number of petitioners who have approached this court for appointment on the plea that they are qualified from the 2022 D.El.Ed course. Detail of candidates who qualify for appointment and those who do not qualify as per board, and reasons therefore shall be furnished.
We have called for give details.
So a detailed affidavit was filed. Now what that affidavit says is recorded in the 29th January order. Please have that.
29th January. Yes.
Wide order dated 22nd January 2024. The respondent West Bengal Board of Primary Education was directed to file an affidavit furnishing certain details relating to candidates. The said affidavit has been filed with copies furnished to learned counsel for the other parties. As per the affidavit, 11,758 posts in various subjects, in various categories in all districts across the state of West Bengal were advertised for the post of assistant teacher for primary classes. After furnishing the detail of the number of candidates who had applied in response to the advertisement, it has been averred, as per draft list prepared, 9533 qualified. So apart from us, under the blue sky, whoever was eligible, 9533 qualified. Why I am
Includes you also.
no, does not include us. We have been kept out of this. We will come after the second paragraph. So these are all pre-2020 candidates who were. Why I am saying, emphasizing this, there are some impediments which I'll come to later and explain those. Now it is stated that a total of, I'll read that line again. As per the,
Are we here in the final hearing?
yes, I'm ready.
Yeah, here in the final hearing.
Yes, as per draft list prepared by the respondents, 9533 candidates qualified, which includes an additional panel of 5% candidates in accordance with the rules.
So total 11758 is the total number of posts. 9353 was qualified.
Only qualified.
Qualified.
Yes. Now it is stated that a total of 2108 D.El.Ed candidates have been found to be not qualified amongst the pre-2020 batch. Now that's not us. That's me. These are two different kinds of candidates who are NIOS qualified and people who were found not qualified as per the board.
No, that's not.
Let's not say no so quickly.
No, I know what I.
Yes, it is. So this is not qualified amongst the pre-2020 batch. Now, it is further stated, and so far as these SLPs are concerned, the petitioners before your lordships are only people like us. There is no other candidate who is a petitioner. They have all applied for intervention.
All of you have applied pursuant to the 29th September 2022 advertisement.
Correct.
We are, as you are concerned.
Yeah, there is no other petitioner.
This is the one which the division bench is talking about.
There is the SLP.
Where the qualifications which they have interpreted the rule to say that you should have actually passed the examination by the date of the cutoff date of 29/9/2020, which is only the interpretation.
So there, and what I am highlighting, there is no other SLP petitioner. It is only people like us. Everybody else is an intervener or a respondent. Respondents in the SLP are fully satisfied. All qualified have been appointed.
Just one more clarification.
Yes.
If it is merely the 2022 September advertisement that we are talking about, where is the question of pre-2022 and all that? What kind of a data is
No, Malord, those are people who were
Why
qualified.
were they giving that data? It should have been simply that the number of posts that were vacant as on the date when the advertisement was issued.
Pre-2020 means those who were qualified prior to our batch, because there were other batches prior to our batch.
Qualified for the advertisement.
Yes, for the advertisement.
For D.El.Ed.
For the advertisement.
Mr. Patolia's batch of
But
D.El.Ed.
I don't need my friend's assistant to explain my case. So
Because-
please take your seat.
I'm sorry.
Wait a minute.
Yes.
Don't interrupt.
Yes.
We'll come back.
I haven't interrupted. That's
Yes.
the reason why I'm.
Let's wait for 2 minutes after him.
No, if your lordship will take your final hearing, I need to tell you something.
No, wait.
I'm not-
Wait, please.
Very well.
Just 2 minutes after.
Yeah,
you
very
ask. You'll come immediately next.
Yes, yes.
Yes. And my friend is not a petitioner. He cannot be representing any petitioner. There are no petitioners.
I
here.
agree.
Yes. Now just let me complete the reading of this order. It is further stated that D.El.Ed candidates from 20 to 2022 batch have not been considered in the draft list due to issues pending in the present matter. Having regard to the fact that as against 11,758 posts in different subjects in various categories, in all, the respondents have found only 9533 eligible candidates, including the additional panel of 5%. It is deemed appropriate to permit the respondents to declare the merit list with a rider that it should be stated in clear terms that the appointments made shall be subject to outcome of the present.
And you
And leave it to the board to do what it has to do.
our decision on the basis of
Correct.
interpretation of the rule.
Correct.
But vacancies board is the one who is actually has the right.
And all appointments made so far are subject to your lordship's order.
The question that arises is on the basis of whether
We are qualified or not.
considered on the basis of the 29/9/2022 advertisement.
Correct. That's all. That's the long and short of it.
Not get into this
Correct.
of the vacancies.
Correct. Now,
Rest of it. In fact, we'll be careful not to tread on anybody else's.
no, there are
Even the power of the board.
there are two other streams whom I must now identify here. One is a stream of people who have qualified this diploma from NIOS. Some
that considered by the improved order.
just no. So what happened?
Relevant for this case.
So what has happened there is these NIOS people were declared ineligible. They went to a high.
I think that came before some other day.
It's just
Keep it aside.
just let me tell you, Lord, complete this narration because how they are completely irrelevant to this controversy. So
Your Lord sent it back to the court, my Lord, because
Correct.
there was a variation.
that's
of the-
correct. So, my lord, these NIOS people, they filed their independent writ petition challenging the action of the board in declaring them ineligible. That writ petition got dismissed by the single bench. They then went into an intra-court appeal. Their latest patent appeal also got dismissed by the division bench. They have filed some SLP. We are not really concerned. Whatever may happen in that SLP, they have nothing to do here. This is one stream of people who want to get impleaded. The other stream of people who want to get impleaded are people whom the board has found ineligible amongst the original 11,000. They are also now coming and saying, we have a problem. This is true. Now, one last thing I want to tell your lordships. Just see this IA which we had filed, where the 2016 rules have been placed on record. Just have a glance at the rule. Since your lordship is hearing it finally, just have a glance at the rule. Because my lord had said that, is there a relaxation power? I just want to point those two rules to your lordships. The current rule 6 is as per, is at page 17. Please have that current rule. Please have a page, kindly have page 5. Just 1 minute. Have you got the IA number? Please have page 5 of the paper book. Your lordships, please. Have you got the IA?
We have 6-2.
ये जो रूल लगाया है ये आई
No, he wants to show something which is power relaxed.
प्लीज गिव द आई
No, maybe it isn't the. Is it an annexure? This can go.
It's performance power.
That is additional part. And also,
of your lordship's paper book. Then I'll take your lord because the rule has slightly been amended. Amended rule is here at page 5. Just I want to just make a point and then leave it for your lordships to consider. Just see page 5.
Page 5 of?
The paper book, your lordship's main paper book.
In the include order?
Yeah, that's right. That's right.
That's right. Page 12.
Yes.
The rule 6 is quoted. No person shall be appointed by the council as a teacher unless he is a citizen of India and has completed age of 18 years as on the first day of January of the year of the advertisement and has not completed age of 40 years as on first day of January on the year of the advertisement. So what is required on a particular cutoff date, the rule itself says 6.1. Now what is 6.2 which has been interpreted? And according to me, my lord, the view is not correct. Is the candidate shall possess the minimum educational and training qualification as prescribed by the NCT on the date of advertisement.
It's a prescription of
Correct. Absolutely right.
very clear.
Absolutely right. And what the NCT prescription
Not intending to lay down a cutoff date.
absolutely right. And now see the advertisement at page 219. Just see that also now only, so that your lordship just has that. Page 219. The advertisement clear.
Much turns on the stand of board.
Now see the stand of the board. The stand of the board is reflected. The board is
Then that's a part of the advertisement.
correct. Page 7.
The issue is whether the advertisement is contrary to the rule or not.
Correct.
You never committed any mistake.
So 29th September is the advertisement. That includes us. Now please see the stand of the board before the division bench. The board says we created the mistake. That is page 12 onwards. And now before this quote, your lordship may only note in the written statement they have conceded. They have said that if they are eligible, just your lordship may see written statement page 15. They say if this court finds merit in the argument, then please permit them to be considered in the recruitment process. That's the board stand.
Mr. Bina?
Yes.
You want to speak?
My lord,
Yes,
I
after
am not
here, Mr. Gopal Singh.
adding just very, very small things.
After him, we'll hear Gopal Singh.
Yeah. My lords, my submission is only this much, that all the appointments that have been made before this court are subject to the outcome of the present matter. So even those people who have been appointed are subject to outcome number 1. Number 2, we are about 916 odd.
Okay.
Our merit has not been disclosed. That merit is what my lords have required, my lords. So those of us who will be in the order of merit as per the selection will come to this court.
You are not getting into numbers.
No, my lords, I'm not on numbers. I am only in terms of all
The
appointments.
decision of the High Court, that's all.
My lords,
And there is no other petitioner. These are all applicants, interveners here.
my lords,
Who's
that is
interviewing?
basically to answer the applicants. So our merit is going to be what is my lords will determine. We are the
Both of
petitioners.
you both are for the present specially petition.
We are for the present specially petitioners before the High Court, against whose order we are before my lords. My lords, all three of
And
us.
as a matter of fact, your lordship can record 9,000 and odd people who are the pre-2020 batch. They have already been appointed, and their appointment is subject to whatever your lordships will ultimately decide.
Exactly.
But they need not be disturbed even if we are to be accommodated, because more than 2,000 vacancies are already there, and I am told that only about 1,900 of us have qualified.
Because the single judge will not be
You are saying that more than 9,000 have been appointed.
9,000.
Figures are below.
Mr. Jaideep can give.
Let I'll give you a lordship. 9,000.
I'll come back to you in a minute. In a minute. We have to hear you mainly, more than anybody.
And then
Kindly hear us also, because we are the appellants before the High Court and we
Why will we not hear you? Why are you name?
Even before the learned single judge below, the stand of the board below, I just read those 4 lines. It has further been stated on instructions by Mr. Saikat Banerjee for the board, learned advocate for the board, and 10 qualified candidates who are undergoing this course.
Get the point. Get the point. Thank you.
And qualified will be given opportunity to apply in the recruitment process. This was the stand.
Yes, Mr.
And please note page 147 is the certificate given to us by our educational institution that our training is complete. And this is in June 2022. Page 147 of the paper.
lastly, my lords, it was the board who then amended the notification
This sheriff.
to allow this.
Yes, Mr.
That is 29/9/2022. which is board's own notification that allowed us to participate. So board cannot take any kind of a dichotomous stance.
Who are you?
I'm just clarifying. I'm not a petitioner, Mr. Patwala. I said it.
You filed an application for
I'll just explain why I'm here. Also.
Filed an application.
I filed two applications. It's IA 63429 of 24.
Yes, for implement.
Yes, and IA 174350 of 2024.
1743.
50 of 2024. In the first one, there are 464 of us. In the second, there are 60 of us. Together, 524. We are not, I just want to clarify.
Who are you? Just
I'm explaining. Just take half a minute.
Take.
I'm not those NIOS candidates. That's perhaps somebody separate. That's a separate issue. That shouldn't be here. Who we are is, I am the D.El.Ed qualified candidates who had qualified it prior to the advertisement. Therefore, not like Mr. Patwalia's and Ms. Arora's clients.
Who applied prior to?
No, who had fully got our D.El.Ed well in advance of the advertisement, got our TED qualification, we were fully eligible. Now, because of the first order of your lordship, which said no merit list would be issued, which came in July, subsequently in January, and I'm saying because your lordship had taken this for final hearing, I'm not reading it out, but please do take a look at the affidavit that was filed by the board in compliance to the 22nd January 24 order. That has all the data, all the statistics, etc. And that's the reason I'm here.
22nd January.
22nd January. That has all the data. It'll explain what the numbers are, how many applied, etc. Broadly, there are some 11,000 odd posts, 14,000 odd people applied. A few of them are held to be not qualified. They're eligible but not qualified. Some of them are held to be not eligible, which includes Mr. Patwalia and Ms. Arora's and Mr. Rahim's clients. They are obviously saying that they are eligible. Now, I am here only for this reason, that after this affidavit was filed in the Supreme Court, your lordships by this 29th January, and they annexed with them the list of those who had qualified. In that list of 9,000 odd, 9533, which is the number recorded in the 29th January order, I am not part of that 9533, even though I was fully eligible. Now, we don't know the qualifying marks at all. I didn't have an avenue to challenge this elsewhere because the merit list is frozen and being tweaked only by this court. Therefore, in March, I filed my application here, saying, please just ask the board to divulge what the marks are of the qualifying so that I can know why I have been shut out and allow me to be permitted to contest that issue if it is made transparent. Right now, nothing is available with us. We know 9533 is the list that they have drawn up. Now,
That is a separate house.
I'll just clarify. I'm not locking horns with them. Whatever they succeed, they succeed. But as far as I'm concerned, because the rule 8 is the relevant rule, rule 8 doesn't provide for any cutoff marks. So I'm not clear how there has been an exclusion once I have the D.El.Ed and the TED qualifications, and you have got a paltry number of applicants, in any case 14,000 odd against 11,000 posts. It's unclear on what basis my exclusion has happened. Therefore, as far as I'm concerned,
Did you ever go to any court about this?
I came directly here. I came in March because I had no knowledge of the numbers until the last week. I did. I'm admitting. I'm just telling you why I'm.
This is not the way to challenge my lord.
This is not the way to interrupt me. No, please let me complete. Last week of January, I get to know because of the affidavit they have filed here. They don't let us know there. They file it here. So my plea is only this,
Okay.
because Mr. Patwalia has made a without prejudice submission as well, that those vacancies, that 2,000 odd which remains, they can fully fill those up. My concern is there. That's why I'm treading on their toes a little bit. I'm just want to make my plea. Therefore, either my issue has to be considered somewhere. So if your lordships feel that it should not be considered here because you're dealing with a prior issue, that those vacancies should be held until my plea is heard either by this court or by any other court. That liberty I want to reserve because
the process was gone through in March
they should have.
2024.
This is something they should have divulged
This is
about the basis on which I was called for the interview. I took part in the interview.
Okay.
Suddenly you say there are cut-off marks and I'm
Consider your case.
So we need to consider. I'm grateful.
No, my lord.
Okay.
One submission.
My learned friends, matter is being considered. Your lordship has sent it back support to.
Part of the
So
same.
your lordship will not be able to deal with all facts.
We are excluding.
We are part of the same notification.
Maybe.
That doesn't help.
And our problem was the equivalence of 18 months to months
All right.
years, and that has been referred to by point number 2 by my lords.
Okay.
Therefore, we only need to be protected. Some seats to be vacant for us. So tomorrow, if we get an order in our favor, we should have some remedy.
All right.
That's the
Consider your case.
Yes.
Lord, our stand is this. We had put it in the advertisement. Just see the advertisement which had come. That is to be seen, my lord, in page 7 of the
Lord,
order.
we have an urgent passover in the next court. I'll just do it and come. One. Great.
My lord, page 7 is the clause which was found to be objectionable by the division bench.
Yes.
They see that clause, which is a
You have
clause.
seen your affidavit also, Mr.
Yes, yes. My lord, we had taken a stand.
We are in consonance
Yes.
with the stand taken by you with respect to the interpretation of the rule in your
But
affidavit.
my lord, there is one difficulty I'll point out, my lord.
Yes.
6.2, rule 6.2, page 5.
We'll go by the High Court judgment.
The candidate shall possess the minimum educational and training qualification as prescribed.
Right, huh?
Yes.
Yes, page 5 of the interim judgment. Rule 6.2.
Yes. Yes. Tell us.
The candidate shall possess the minimum educational and training qualification as prescribed by the National Council prevailing on the date of publication of the recruitment notification. So, my lord, what is to be
It is to be
prevailing?
what rules subsist as on that date.
That's right. But if we look at the rules, date is a qualification required on the date of recruitment notification.
Absolutely correct. That's
Therefore, my lord, if they didn't actually have the TET qualification on that date, please don't keep interrupting. Please don't interrupt. My lord, what the qualification must be there on the date of the publication. Therefore, my lord,
Are you changing your stand?
my lord, division bench, my lord, we are accepting the division bench. Division bench.
You change your stand.
Yes.
Why?
My lord,
Why?
my lord, there is no why. I am a counsel here, my lord. I am a counsel before your lordship, my lord. We are arguing a question of interpretation. We are arguing a question of interpretation.
Well, we can explain the reason.
Not necessary.
Because
we can easily understand.
No, I don't think my learned friend should hazard to explain the reason.
We'll not even ask. We will give our own interpretation.
Lord,
How does it matter?
I have been given the reason, my lord, but that relates to the single judge, and I don't want to repeat that before your lordship.
All right, we'll pass on.
now, so far we have succeeded before the division bench. We have succeeded before the division bench.
Okay, we should hear you. You are right.
Now, your lordships, my lord.
Tell us your interpretation.
Yeah, but
You are supporting the High Court judgment.
of course, my lord, your lordships can
You just purely focus on law. You don't.
no focus on law, but your lordship always needs certain facts.
Not necessary.
Now, I tell your lordships why this has come up.
The law. Tell us.
Now, your lordships kindly see the amended rules. My lord, that's have been given to your lordships by way of my lord, this is additional documents at page 20.
8 of 5.
At 14245. My lord, IA number 142450. Probably the appellants for loss.
Tell us.
Place 20.
Tell us your points and your
Losses, clause 6, your losses, rule 6, unamended rule 6, page 20. So far, unamended rules, rule 1 of rule 6 remains as it is.
14250. 42450.
So 50. Page 20.
Page 20.
Rule 6, sub rule 1. At the bottom, your losses kindly see this remains as it is, both amended and unamended. This deals with the age. Normally, this is your losses will find in every recruitment rules that is to be age should be considered with reference to the first date of the year of the advertisement. So it doesn't deal with the acquisition of the qualification. So for unamended rules 2, your losses find the candidate shall possess the minimum educational qualification specified by the National Council for Teacher Education and the notification relating to eligibility of the candidates issued by the Ministry of Human Resource Development, Department of School Education and Literacy, Government of India from time to time, read with the relaxed qualification issued by that ministry from time to time pass the test. But I tell you, losses in West Bengal, the training qualification was relaxed at that point of time. But in respect to other state also, but the West Bengal. So this was the pre-amended rules of 2016.
Contrast it with the amendment.
And then you'll see page 423 of the paper book of your losses, running page 423.
What is
423. You'll see since this was amended by notification dated 22nd December 2020, starting page 421.
What is the date of this?
Notification 22nd December 2022. 2020. 421.
The second
December 2020.
Yes.
Page 421, starting page. The relevant page your lordships, 423.
Yes.
Kindly see my lord, sub-rule 2 of rule 6.
Yes.
The candidate shall possess the minimum educational and training qualification. We are concerned with training. As prescribed by the National Council for Teacher Education, prevailing as on the date of publication of the recruitment notification. Why this amendment was done? Because by this time, the state of West Bengal got huge number of trained candidates, which was not available before 2016.
Yes.
So, my lord, this, my lord, if you lost it now, now your losses will find this was the rule. Number according to us, our submissions, one must possess the qualification prescribed by the NCT on the date of the recruitment notification.
All right, thank you.
This is one thing your losses.
Okay.
And your losses will find this on the date of the notification, they didn't have the qualification.
That's what your High Court also upheld.
Now your losses will find
your view.
your losses will find your losses as far law laid down by this court in 2005, 2000 volume 5 SCC, page 262, paragraph 13. This has been quoted by the learned division bench. If I just take your losses, paragraph 13.
What is the citation?
Citation 2000 volume 5 SCC, page 262, paragraph 13.
Read relevant portion.
Paragraph 13.